We're now speaking about international obligations versus domestic law, specifically taking a look at the 1951 Geneva Convention, or to be more specific, the Refugee Convention. Now, let me introduce you to this topic by speaking about a case that Justice Frank C. Prasad was overseeing. Justice Frank C. Prasad was presiding over a judicial review and constitutional claim of Venezuelan national Johan Jesus Dominguez, who challenged a deportation order by the Minister of National Security in March. Dominguez, 33 years of age, was charged with illegal entry in August of last year. His application said he fled Venezuela in fear of being persecuted by the country's government. He was granted refugee status by the United Nations High Commissioner for Refugees, the UNHCR, in April last year, so this would have been August of 2021, and in April last year, but was arrested months later while in a taxi in Faizabad. The father of four pleaded guilty to illegally entering TNT and was fined $2,000. In March of this year, he was issued a deportation order. Now, the controversy surrounds the judgment of Justice Frank C. Prasad, and that is refugees and asylum seekers can be deported if they run afoul of local immigration laws, since obligations under the 1951 UN Convention and the principles of non-refoulement do not apply to TNT, as they are not incorporated into the domestic laws in TNT. It means all migrants are subject to provisions of the Immigration Act, and they, asylum seekers and refugee seekers, can be deported even if they are registered with the UNHCR. So that is the introduction to this topic. Yes, quite a long introduction, but you need to have an understanding of the case and an understanding of the convention before we can continue. So I'm now joined by my guest, the Executive Director of the Caribbean Center for Human Rights, Ms. Denise Pitcher. She's with us via telephone call. Hello, Ms. Pitcher. Welcome to the program.
Good morning, Ketan, and thank you for having us.
Well, thank you for joining me. Ms. Pitcher, your reaction to the judgment by Justice Frank C. Prasad?
So it's very concerning. As an advocate of human rights and an advocate of refugee rights, our most immediate concern is that if the family is deported, that they will be sent back to a situation, a dangerous situation from which they fled. And it then, of course, this ruling, it paves the way for other persons to be deported and send persons back to a situation. A lot of people that are fleeing persecution, are fleeing very dangerous situations. Sometimes they are fleeing the threat of death, threats of safety and to their safety and security. So it's very, very worrying.
Mm-hmm. Ms. Pitcher, we signed onto this convention in the year 2000. It has been 23 years. We have not, however, incorporated it into our domestic laws. Are there obligations by the government as signatories to the convention to incorporate domestic laws?
Well, that's it's understood by states that once they've acceded to these conventions, the next step is to integrate it into domestic legislation. And while we have not integrated it into domestic legislation as yet, there have been actions by the state that can be interpreted as complying with its obligations. I mean, for example, we have a refugee unit that's been established within the Ministry of National Security, and that does deal with refugees and asylum seekers. So we are already complying with our obligations. We have allowed persons to come enter Trinidad and Tobago and register with UNHCR. So we are honoring our obligations, even though it's not been incorporated into domestic legislation. Mm-hmm. And it's also important. This is also a very important point to emphasize is that Trinidad and Tobago We're a member of an international community that strives to uphold and protect human rights. And, refugee rights are human rights. And, sending persons back, this particular case, they're recognized refugees. So they're entitled to protection, human rights protection. And by sending them back, we're sending up, we are possibly placing them at risk.
Mm-hmm. What are your thoughts on the 2014 policy that government formulated and was adopted by Cabinet? I know you mentioned that, yes, you see the efforts being made, but specifically to the 2014 policy.
So the 2014 policy, it definitely needs revision. At the time that it was drafted, we did not have the numbers of asylum seekers and refugees that we now have. And it's also not, comprehensive. It doesn't take into account a number of different issues that asylum seekers and refugees encounter. I haven't taken a look at it recently, so I can't tell you off the top of my head. However, we did go one step further and develop what's called Immigration Manual Volume 1, which is a very comprehensive framework that guides the state in how we treat it with asylum seekers and refugees. And it's very detailed, it's very, very comprehensive. And so if there's supposed to be any revision of this policy, as the Minister of National Security has said, our hope is that the framework that has been outlined through the Immigration Manual Volume 1 will also be taken into consideration in the development or the refinement of a refugee policy.
Mm-hmm. Now, here's where it gets a bit confusing. Article 31 of the Convention states that no signatories are, and I quote, to impose penalties on account of their illegal entry or presence, end quote, of any asylum seekers. So therefore, is it that this particular order is now actually us contradicting what we are signatories to?
Yes, correct. So the non-penalization principle is a fundamental principle, of the Refugee Convention, and it's customary international law. It's understood by everyone that persons who arrive at our shores and declare an intent to seek asylum, they should not be penalized for illegal entry or irregular entry. And the reason for that is when people are, fleeing their country of origin, a lot of the times they don't have time because of the urgency with which they may have to flee. They may not have time, to prepare travel documents. They may not be able to get a visa. They may not have travel documents. Oftentimes, they may not even have the money to take regular routes. And sometimes, they may have to go on foot or through, cheaper, irregular routes. And so that non-penalization principle is there to cater for all of these challenges that persons fleeing persecution may have to deal with, and hence they should not be penalized.
What do you think this now means for Tobago in terms of the international arena? This particular case, how would it affect our status internationally?
I mean, it's definitely something to concern the international community and our international partners. Our hope is that the attorneys appeal this case, and hopefully there's a different outcome that respects the human rights of asylum seekers and refugees. But there's no question that members of the international community who also consider themselves defenders and protectors of human rights would be concerned by this ruling.
Mm-hmm. Now, you're quoted as saying that there is a need to protect these people, asylum seekers and refugee seekers.
Yeah.
But there is also an understanding that in terms of our social positions, our economic positions, that may be very difficult to do so. is it possible for TNT to somehow find a balance, or is it just too difficult of a task for us to handle at this point?
And that's a very good point, right? And it's true. We are a small country, and our resources are limited. But we do exist in a reality where we are right next to one of the largest migration movements since World War II, and we have to find a way to manage it because they are coming to our shores. And they're coming through irregular routes, and that's placing them, at risk of being smuggled and trafficked. And our objective should be to have some sort of humane migration pathway. Additionally, Trinidad and Tobago, we have not really engaged as substantively as we should with other regional mechanisms and international mechanisms that would provide support, technical expertise, and capacity building, and also resources that could support our efforts to manage this influx in a humane way. For example, we did not sign on to the LA Declaration at last year's Summit of Americas, and within that declaration, it talks about responsibility sharing. It talks about providing resources to member states who sign on to declaration. So those are some ways that we can receive assistance and to be able to manage it. Because right now it's almost as though we're kind of looking at the situation and throwing our hands up in the air. Okay, well, we're a small country, and too many people are coming. To what we have to manage it responsibly. Mm-hmm.
So 25,000 asylum and refugee seekers from 38 countries as of April 2023.
Yeah.
Do we understand from all levels, whether it be from a government perspective or even from the public perspective, do we understand the obligations that we have to protect these people?
Well, I still think the refugee concept is still relatively new to the general public, and this is where CCHR continues to engage in educational efforts. Other international organizations here, they are also doing sensitization exercises to create that awareness, and they've also done sensitization exercises with state agencies to so that there's a greater understanding of our obligations to protect asylum seekers and refugees, and we will continue with these efforts. What I would emphasize is that they are vulnerable people, and they come fleeing very serious circumstances, and at the very least we should treat them with humanity and have a greater understanding of the fact that they're fleeing serious persecution, dangerous situations.
Mm-hmm. Ms. Pitcher, I want to thank you very much for joining me this morning to share with us your thoughts, your reactions as to this particular ruling, and stating where we're at and what more could be done. As mentioned, I think I agree with you that this concept of refugee and asylum seekers is still fairly new to the public, so education is quite important. I'm not even sure if we were aware, if the public was aware that we were actually signatories to the convention prior to this ruling. So thank you very much for joining us this morning and for sharing this information with us.
Thank you for having me.